You are watching Court TV Live, your front row seat to justice. I'm Julie Grant. We're in day number 7 of the trial of former Minnesota police officer Kim Potter. We've seen 6 days of presentation by the state of Minnesota. They rested their case in chief this morning. Take a look.
Does the state have any further witnesses?
Good morning. No, Your Honor, the state rests.
All right, then the defense moved for judgment of acquittal. That is a standard motion. They've got to make it. It was expected that it would be denied, and it was. Then this afternoon, we saw the defense case begin. We know they don't have to call any witnesses, but they are choosing to. And at some point, Kim Potter is also expected to take the stand and testify in her own defense. She told the judge that this morning, said she didn't need any more time to think about it. The defense, though, did not choose to start off by calling Kim Potter. Instead, they called their own use of force expert to talk about Kim Potter's actions during the traffic stop that turned deadly with 20-year-old Dante Wright.
Was the warning taser reasonable under the circumstances in this case?
That is specifically taught in the lesson plan. Number of reasons for that. It's really not for the suspect. It's more for the officers and others around the event to understand that a taser is just about to be deployed.
We heard testimony yesterday that the taser in this case was, or the assumed use of the taser was too close to Mr. Wright to be effective in its impact. Do you agree or disagree with that?
That's completely untrue.
Well, tell us why Mr. Stoughton's opinion is completely untrue. 2
key reasons. The first is the Taser 7 specifically is designed to have a very wide arc with the close range deployed probe. The standard arc deploys about 1 foot every 7 feet. And one of their corrective measures with the 7 was to figure out that many police confrontations with suspects are at close range, and that degree of spread was insufficient to get neuromuscular incapacitation. So, number 1, the 7 spreads wide at close range by design with the close cartridge. Independent of that, the physical positioning of a seated suspect changes everything.
How so?
Literally, as you or I sit here, if you envision a shot just below the chest or sternum area, which is a key aiming point for the upper probe, from that probe to the probe into a thigh is about 12 inches, which is marginal for neuromuscular incapacitation, as they say, as the crow flies. But on the body, it's about 36 inches. Because as you stand, the electricity takes the path of least resistance. It doesn't go through the air. It follows the body. And to connect one probe to the other, it goes down the side, down the leg. And so a seated suspect changes everything as it relates to probe spread, because their body's bent, and you end up hitting low and hitting high, not because you're at a distance correct for that, but because of the angle of their body.
Joining us now in Minneapolis, Court TV legal correspondent Julia Janae following this case for us. She's been in the courtroom as well at points in time. Okay, Julia, let's start, if we can, please, with what is coming up for the defense. We know this wrapped up before the lunch break, and then they were sent off for their lunch. After that, it'll be time for a new witness. Any guesses as to who the defense may call?
Well, it's possible that they'll call their other expert. They have 2 experts that they put the court on notice about. Here's a list of some of the names that we know are on that defense witness list. You mentioned one already, Julie. Kimberly Potter, we know, is expected or plans to take the stand in her own defense. Dr. Lawrence Miller is another defense use of force expert. So they've already put their first expert on the stand, Stephen Imes. They could follow it up with another expert before the defendant takes the stand. We also expect to hear from the former Brooklyn Center Police Chief Timothy Gannon and Officer Colleen Fricke. She is someone who was on the scene. She has a body camera footage that we know the defense wants to get into evidence, wants to show this jury. It's on their very short list of exhibits that they put the court on notice that they wanted to enter. So we may hear from not only Officer Fricke, but other officers who are going to testify to this defendant's good character, the fact that she was peaceful and law-abiding as a police officer.
Oh, okay. So that's something we can expect to see. Julia, thank you for that. I know we don't know what order exactly, but let's say, for example, this other expert comes up next. In doing some of the research, which I know you've done in preparation for this trial, we understand there's supposed to be this phenomenon that the expert's going to testify to about something called slip and capture error. Can you touch on that, please, and what it will mean to this case?
That is exactly what Dr. Miller is expected to testify about. We didn't hear it from Dr. Imes, so we likely will hear it from, or rather, Stephen Imes. He's not a PhD. Dr. Miller is a PhD. And slip and capture is essentially this theory that someone reverts back to a training that they had when they are in a certain situation, one where their adrenaline may be rushing, that they won't necessarily use the more recent protocol or way of doing things, but if there's another way that they've done it in the past, that they may revert to that. This goes to the defense argument that the officer, Kim Potter, that she wasn't often using her taser. There was another method or training that she was trained on at least 10 years earlier. Also, she was an officer for 26 years, so there were many different types of tasers that she held. There's a look at the one that she was actually carrying and the 9mm Glock handgun that she pulled instead of that taser. But this slip and capture theory that the doctor is going to be explaining to this jury is supposed to explain what happened that day, which it can be very difficult for likely these jurors to understand how this mix-up could be so deadly.
Yeah, and that's such an important question, Julia, isn't it? Because so many people are just asking, how can an officer with so much experience have mistaken her firearm for her taser? And it goes to something, we had that use of force expert David Wright touching on this yesterday, that so many people who are looking at this case from afar have never been in that situation, as you pointed out, where you have adrenaline rushing and it's stressful and focus maybe going in different directions. So this ought to be some very interesting testimony to hear in this case and how it relates to what Kim Potter was doing that day. But at the end of the day, the bottom line we know is whether or not this mistake was criminal. You know, tell me, I know that the prosecution really fought hard to keep some things out with the defense's last expert before the jury was even brought in. I know you were watching closely when that was happening. What didn't they want the jury to hear?
They didn't want this jury to hear him get into deadly force. The fact that deadly force, the fact that Kim Potter did use her handgun in this situation, that may have been justified. We heard it come up some on the cross-examination of Michael Johnson, the former sergeant for Potter, who actually testified for the state, but did some real damage in his cross-examination testimony, saying that he believes under the statute she would have been able to pull her gun in that situation. Today, we did hear this expert talking about deadly force because the judge ruled that this is part of the case. These are the facts, and the jury should be able to hear and understand the facts. She didn't think that it would confuse the issues at all, and especially, I believe, since so many things have come up about deadly force, to not have it explained by this defense use of force expert, Stephen Imes, would have likely left a hole for these jurors.
Oh, yeah. This case is not an easy one. That jury's going to have a tough job, as you have pointed out through your reporting, Julia. Thank you so much, Julia Janae, live in Minneapolis for us. We'll be checking with her throughout the day today. We're going to turn now to our legal analyst, Daryl Cohen, who's joining us on the program from Atlanta, Georgia, to weigh in on where we are at this juncture and what is coming up. Daryl, I know you've tried cases on both sides of the courtroom. You've served as a prosecutor, you practice criminal defense work. Tell me, what is your assessment at this juncture, where we are today, right now, with the state having all of its evidence in, and now the defense choosing to present evidence?
Well, first of all, Julie, I think that it's important to be able to look at the jurors, what their facial expressions are. How many times, if at all, do they look at the former officer, Kim Potter? What do they think about her body language, her facial expressions? And you brought this up before. So where am I? I think that the use of force is important. I think it's important to know that when you can talk about it. When you're in training, it's easy. There's no adrenaline rush. We know it's training. But all of a sudden, I don't care if she's been on the force for 26 days, 26 months, or in this case, 26 years. There's an adrenaline rush, and you're doing what you think you should do. You may or may not revert back. I'm not going to go there, but you are under the gun. Excuse the double entendre, but you're under the gun, and you have to make a decision instantly. You don't have a moment or 2 or 10 to drop back, think about it, and then move forward. You are right in the middle of what's going on, and you have to make that decision at the very moment. So I am impressed at this point with what the defense is doing. If I were defending her, I would not use my second use of force expert until the end. I would wait and finish with my use of force expert. And I think it's important to note that, and I want to go back to her first one, I disagree with my colleague Eric. I think the fact that he was pro bono, that he was free, that he was not being paid, says not that he's trying to protect anybody, but in his view, he thinks there's a miscarriage of justice, and he is offering his services, all the years of his expertise, to say, I don't like this. This is wrong. And that's why I think he was there. And that's why I think the prosecutor finally made a good move by not going into his free testimony, his not being retained. I think that is important not to go into.
It is, Daryl, and I'm glad you just did that, because it shows an example of good lawyering, what you just did and what Eric did. You know, you're taking a set of facts and then you're bringing those facts to whatever argument you want to make at the time. You know, and Eric was saying the state should have used that fact to show bias, and he gave examples of how they could have done that. And then you just showed us how the defense could be doing it. Like, that is exactly it. That is the purpose of great legal analysis and being able to see a case from all sides here. I just felt like that expert was very, very strong for the defense, and the state, as you pointed out earlier, if they didn't have specific points where they wanted to try to undermine his testimony, show contradictions, do something that is going to be impactful, they should have either done no cross at all or just a very cursory cross and sat down. Because that, to me, that just accomplished nothing. All it did was, in my opinion, make the jury like him more and reiterate the points that he made before. So, yeah, and to your point, tell us more about when you're in the practice of crossing an expert. I think this is a great time to do this because you've done it. And the way I was always taught is, you know, you're never going to talk use of force with a use of force expert, right? Because they're always going to beat you if you're the lawyer. You know, so you're going to talk other things. You're going to talk where you can make points and where you can score points with the jury. What should that prosecutor have done, in your view, to have had a more impactful cross-examination with that guy?
Julie, I'm going to go back to what you just said. I would have taken what Irving Younger, who was the expert on cross-examination, told me and told so many other lawyers and law students. If you don't think you can do anything with this witness, say, thank you very much, Your Honor, I have no questions, because you don't hurt yourself. In my view, he hurt himself because this witness, though he was called by the defense, he was actually testifying for the truth, which was what all of us want in a trial. If you have nothing to hide, then you hide nothing. And he was trying to say, I am an expert. Yes, the defense called me, but I'm testifying as to the truth. I could have just as easily, if the court wanted to, call me as an expert witness by the court, not for the prosecution, not for the defense, but for the court. And I think that's important for everybody to understand, that just because you are called by the prosecution or the defense, it doesn't mean you're going to change your testimony. What it does mean is, hopefully, you will be testifying as to the truth, and the jury can hear that, the jury can see that, and the jury can feel that. Exactly.
I think what you just said, we saw an example of last week with that Major Michael Johnson's testimony. He was the state's own witness, swore to take an oath to tell the truth when he got up there on the stand, and he delivered probably the most favorable thing he could have to the defense in saying that he could have been dragged and the use of force would have been justified. And now it seems like the state, I think what they're doing, Daryl, is they're so afraid of that impact that had on the jury that they're shifting their focus from where it should be to try to blunt what damage has been done by that remark in whether or not she could have shot Dante Wright legally. So I have to leave it there for now, but great points you made, Daryl. Thank you so much. We're going to squeeze in a break, I'm being told. When we return, we know the jury's going to be back in a couple of minutes in Minneapolis, Minnesota, and we're going to look at some conflicting testimony that came in by two of the state's witnesses. Our Julia Janae was explaining this to us a short time ago. Their two witnesses gave contradictory information. This is a problem. And we're also going to talk to you about the new statute the jury will have to be considering in this case. That's all next for you here on Court TV Live.